So on the state exam, and something that you need to understand when you're talking with your clients, is the recording and acknowledgement. So when we record a document, it's basically a legal acknowledgement that instruments, paperwork exist stating that in the official records of the county, the property is transferred in some way, shape, or form. It could be by sale, by will, by trust, by death, whatever the case may be. It depends on what's going on. And there's some kind of acknowledgement, and it's a signed and verbal statement by all the persons involved that they have signed the document on their own free will to transfer the property, either by sale, will, or whatever, and they are acknowledging all of the signatures. So hang on thought. Recording gives constructive notice. Understand that term. Constructive notice means basically, as of immediately, this property has changed ownership, okay? Or title has changed, okay? It notifies everybody and public entities, okay, that instruments exist, proving, instruments being paperwork and legal documents, that the property has changed hands. The constructive notice is presumed by law to have been acquired by a person whether or not they have actually examined the paperwork. They may have signed it, never even looked at it, okay? And what's happened is that there's a recording of a deed or taking possession of the property, physically giving constructive notice of the change of ownership. If the property, and you're going to see this as a question, is sold to more than two people by some unscrupulous seller, the person who records first gets the property. So let's say that I am Dastardly Don, and I decide I'm going to sell my house for a ridiculously low amount to 4 different people. The first 9 o'clock I meet with buyer A and I say, I'll sell you my house for $250,000 cash. Here's the deed, give me the cash. They wire me the funds. I immediately go over to victim number B at noon and I say, hey, look, I want to sell this property for $250,000. You know, here's my deeds, things like that. Sign it, everything, have a notary public, makes it all legal and everything else. I turn around, then I go to C, and I do the same thing, and then later in the evening, D, the same thing. Who gets the property? It's whichever of those 4 people record the deed first. Everybody else has got a cloud on title, and here come the lawsuits. And I'm already just disappeared down to some warm beach, preferably in Mexico, okay? So there will be exam questions on that level. And always remember, it's the guy who, or gal, that records first that actually becomes the new owner, okay? So actual notice is knowing that the change of ownership has taken place. So there's a lot of confusion about who gets paid first when it comes to some type of encumbrance or deed. Remember, mechanics liens must be recorded. This is a plumber who did some work on your house and you didn't pay him. So he puts a lien on the property because he wants to get paid. Judgment liens, you ran over somebody's little puppy dog and they sued you for $10,000 because that's a family member, and they put a lien on your house to pay for the damages and the burial and all that good stuff. Those actually have to be recorded and public for them to be valid. Okay, that's number one. Number two, what a lot of owners do, and I think this is a very smart thing to do, is they declare a homestead on their own property. And what a homestead is, and it's in your book, and I definitely want you to read this because it may be a question on the state exam for you, is I have a property and I declare a homestead on it because it's my principal residence. If I get sued and they win in court, I don't lose every single penny of equity that I've developed over the years. They can only sue and take a certain percentage of it if I have declared a homestead. What it does, it prevents Californians from becoming completely destitute should they have an accident and cause damage to someone else, okay? So all recordings are also done in the county that the property is located in. There are no exceptions. Even if the owner lives in New Hampshire, or New York, or Texas, they must have someone here record the deed and transfer of the property and title. So I want you to remember something, because you're going to have these clients that just don't get it, okay? And they're trying to get one over on everybody, if you know what I mean. They're trying to do something a little funny, okay? And these are usually people that have some kind of tax lien that they know of, or they have a judgment that they know of. And almost number one is child support that they're not paying, and there's a lien on the property, okay? And they're trying to sell the property in hopes that you won't notice that there's a lien in the property, and hope that nobody else will notice. And guess what? Even if the title that you pull on a property, because we do pull title on property, you should, for every property you put into escrow, the first thing you need to do is pull that title. Do it before you write the offer if you can. And make sure that the owner is the owner and there's no obvious liens on the property, okay? But there might be a lien that pops up because they just had a judgment last week and now they're trying to rush the property to sale so that they can get all the money. And it does happen. It's very rare, but it does happen. But in order of who gets paid first, it's always going to be the tax man, whether it be the California one of the FTVs. People worry about the IRS. Actually, California's FTB office is just brutal. I mean, if you owe money, they don't negotiate, they don't lower the interest rate, they don't do nothing. You either pay what they want or they'll just take everything, they don't care. Okay? IRS, at least they'll negotiate with you. Next is special assessments or any overdue HOA fees. So if you had a fight with the HOA and you didn't pay them for a year, guess what? They're second in line. Mechanics liens or judgments. These are things like child support. You ran over a little girl. Mechanics liens, you didn't pay the pool guy for the new pool. Then the outstanding mortgage gets paid. It's not here, it's here, number 4. So if there's an outstanding mortgage, they get paid. A HELOC, home equity line of credit. If you have a second or a HELOC on the property, there goes my light again. I don't understand it. It only lasts for like 15 minutes. It sucks. Wow. Then what am I have to fix that? What happens is the HELOC gets paid, and then number 6 is any private loans that you may have that has a deed recorded. They're ultimately the last people that get paid. Okay. Acknowledgement, this is pretty self-explanatory. It has to be a notary public. You must have a valid ID. And most importantly, do not give legal advice about how to take title. Clients, consult an attorney. You know what? I took title on this property differently than this property, differently from that property. So what I recommend you do, talk to your family attorney, pay them the $500 for the hour, and they'll tell you exactly how you should take title, okay? So next part for this class is going to be encumbrances, and we'll shoot that video for you and have it ready to go. Thanks. Turn off.